Good evening. First of all, thank you to the President, to the former Chief Justice, Dorit Beinisch. On such turbulent and difficult times, thank you for coming to our conference. And I'd like to start with a question. If you could address the main argument or one of the main arguments at the basis of the reform, and the argument is that the Supreme Court actually over the years has not allowed or enabled the government to rule. A government is elected, it has a policy, it wants to implement that policy, but the Supreme Court prevents it from implementing it by judges who were never elected and who appoint each other, and that's not democratic. So the purpose of the reform is to fix this distortion and reinstate democracy in its proper place. So is indeed the Supreme Court preventing the government from ruling? Is this the question that actually bothers us? Do we believe that this is the problem? The reform, as we've heard this evening, is not a legal reform whatsoever to correct or to rectify legal issues. This is not what's at stake here. It's not even a matter of right and left. The entire question here, why a regime reform? It's because the government seeks to take over all the democratic institutions, three authorities, all under the control of the government. It's the government itself, the Knesset, which is controlled by the coalition, because this is our structure, and the court, which also will not be independent, depending on the government without judicial review. It's not just about the law. It's not rectifying and amending the judiciary. I don't believe that there's anyone who's really concerned that the court doesn't allow the government to rule, because that's, excuse me for saying, is nonsense. The court has a clearly defined role which it gloriously fulfilled over the 75 years of the existence of the State of Israel. According to our structure, in the absence of other democratic institutions, and Avichai Mandelblit already listed the entire list that even the Canadians could say about us. We don't have any institution that can somehow have some kind of control over the government, the tyranny of the majority to defend human rights. We don't have a constitution. We don't have two parliament houses. It's all well known. We don't have any control tools. So our structure is different. Every society, every culture develops its own structure. In our structure, the checks and balances are in the hands of the court because there is no other institution that can do so. Now, the court has never intervened in the government's policy, and anybody who argues that knows that it's incorrect, just like many other incorrect claims we have heard in recent times. As a review instance or a controlling instance, the court, it's not always what the government wishes to hear. If the Knesset or the government, Knesset according to basic right, human dignity, can disproportionately harm human rights by its legislation, who will repeal that law? If the government determines in an arbitrary fashion, or God forbid through corruption or discrimination, who will review it? Well, the solution is there will be no review. And when we think about where we're at today, and we heard from Mano, and what we've heard previously this evening, there are serious security problems, and we had a very good economic situation as far as I know, but we're going to face some serious economic problems. So all these problems are not interesting. The most important thing for this newly elected government, if we think about the territories in Iran, the main problem is whether or not they'll have an override clause or not, or how to appoint judges. It doesn't sound credible. It's not serious. I cannot think of one example of intervening in policy, interfering with policy. It's true that the rulings and decisions issued by the court, the government wasn't always pleased with these rulings, but it's not the role of the court to please the government. You need to remember that the court is one of three branches of the Israeli regime establishment, and it has the DNA of a regime institution in Israel because it is a branch that defends the Zionist values, the democratic values. There's no one else in Israel's institutional structure that can take it upon itself to do this scrutiny or review. If you could bring one example in which you think that there was interference with policy, there is one claim, and it comes from different places. For example, why did they intervene on the issue of the infiltrators, how long they'll be in incarceration? This is a matter of human rights. Of course, the court decided on that, and this is something that really vexed many people. The recruitment issue, military recruitment, is a major issue in Israel because of the political power of the ultra-Orthodox party. So when it comes to the recruitment of the Haredi, as of 74 or 75, with Chief Justice Landau, all the way to the Tal Committee and Knesset legislation until 2012, all throughout these years, it never instructed that there will be mandatory conscription. So these are false allegations or forceful takeover. On the security issue, one of the claims is that as a former, military attorney, that it's the legal experts that prevent the military from fighting. There are former chiefs of general staffs here that can explain the contrary. But what was the role of the court as the Chief Justice at the time? How did you see your role in this issue of balancing between security needs and rights or the law? Well, I think that the court has an exceptionally important role. Some of the things we heard from the perspective of a former military attorney general, MAG, not just an attorney general. I cannot even begin to tell you how much more serious our situation would be in the international arena if it weren't for our court. I'm not just talking from the legal perspective, if we're looking at international law and The Hague, etc. I think that this is the best example which is valued all over the world, and I have had the chance to speak with my colleagues in other countries how in our difficult reality, not somewhere over there, it's not Afghanistan. We were sitting in Jerusalem when buses exploded in Jerusalem. Terrorists were not something foreign to us. Bereft families are not something detached from us. We live in our people, within our community, despite people claiming to the contrary, and to find a way in which the military, and in times of war, to operate lawfully and fulfill its role, which is to defend the state of Israel. I think that the court, indeed, in endless examples, to the credit of the law. What is this similar to? This was the first court that, under very strict conditions, but discussed without avoiding the issue of targeted killing. There wasn't any other court in the world that dared to do it, and it determined the conditions and the restrictions and the need when to allow for it, when to law. So you're taking away the legal basis for the activities of the IDF and the U.S. military. So many militaries in the world rely on this ruling by an Israeli court. This was the first one. It's not such a nice practice, but sometimes it's very necessary. It needs to be limited, and it was recognized with great appreciation by other countries after we were the first ones to address this. And what does it mean to issue a ruling on what's called the neighbor procedure, when you know that our children, our friends, our families are out there, and this is one of the most difficult decisions we reached. And where are the restrictions to use people of the territories who are held in the ways they're held, and to use them as a human shield, actually. The court had to deal with many difficulties, but this balancing act, this is what gave us the ability in inconceivable conditions, because, for over 50 years to be in charge of a population, a civilian population, under such conditions, it's very difficult. There isn't any parallel to this in the world, and I can say that our court determined the balances. It recognized Israel's security needs, and all these arguments of political intervention in settlements, the court never took a stance on the legality of the settlements, and that's a major question, a very difficult question. Let's not play innocent in international law, but it only addressed the issue of seizing private land for settlement purposes. Beyond that, things that Israel is struggling over in the international arena, the court did not enter questions of policy, and for a reason. And we could also say that all the discussions were usually through dialogue between the representatives of the state and the court. There was always a dialogue, and in addition to the constitutional dialogue between the Knesset and the court, there's another dialogue during a court case. You know what? You addressed a very important point. This is a practice that we developed, and I was very much for it at the High Court of Justice, because it's a very special instance. It's the first and last instance. It's a unique instance, and before any sensitive intervention, we asked the representatives of the state officials, to go back to the government, and this is the kind of dialogue we had with state officials. If there's a problem here or there, and the Attorney General can point at the problem, and only after we got an answer that they thoroughly discussed this, then we decided whether the court could intervene. And this ping-pong between us and the government officials, I thought it was a wonderful tool for hashing things out and for non-intervention. No arbitrary intervention on any side. It didn't always succeed, but I think the results were pretty good. And you know what? Before we finish, let's take a look into the future. Where do you think we need to go? How do we get out of this mess? How do we reestablish a dialogue and the trust that some people worked very hard to destroy the people's trust in the court? Look, just like you said, a great effort was invested in order to destroy the trust in the court, because the court relies on trust to a great extent. It needs this trust, and for many years they tried to affect public opinion against the court. But even today, the court receives a much greater trust than all other political institutions that we know of. Can we get out of this if we don't give in to it? I have to say unequivocally, we cannot negotiate under threat, under a gun pointed to our head. And they're not saying that. The Minister of Justice said until Passover we will finish one part, one section, and immediately after Passover, and they're willing to give a week or a 2-week break, and they're not willing. Can we build a new method? Can we examine the disadvantages of the existing system? This is not serious. So you were right when you said, and I think all legal experts agree on this unanimously, everything can be looked into. You can look into the legal aspect. You can see how we can improve and elaborate, but that has nothing to do with what's happening out there. It has nothing to do with these proposals. The proposals have nothing to do with the court. They have to do with the government's desire to take over. If they would stop everything, if this legislation would cease, and they would gather as a committee of experts, serious experts of diverse opinions, including opinions that do not advocate the same opinions I do, but a professional committee that would examine each and every topic to see if there's a problem in the judiciary, and then how to fix that problem. But since this isn't the case, this isn't their goal, this is why we cannot establish such dialogue. And I think that it's critical that this happens. And is there a possibility? Yes, of course. What about basic law legislation? We don't have time to discuss just how important that is. What about the determination what a basic law is? We just heard a basic law is something that the court cannot repeal. But what's a basic law? Every law we wish to pass can be defined as a basic law, because there is no definition, there is no constitution, there is no basic law legislation. And then if we do that, we can do everything. And I think that one good thing has happened to us in this very difficult, even emergency situation. The Israeli public has awakened. The Israeli public understands what are difficulties. We do not want to part with the Declaration of Independence. It's the basis, it's the foundation, the DNA of a Jewish and democratic state. And I think that there's tremendous willingness today for the entire Israeli population to not undermine this basis. This is the basis for our existence as a state. This is how we were established. This is our foundations, and this is what we'll maintain. And if there's a basic law that will cancel the Jewishness, God forbid, or the democratic nature of this country, this is where the judiciary must intervene. Thank you very much. And once again, I'd like to thank former Chief Justice Beinisch on behalf of Israel's security. The Supreme Court has a significant contribution, and maybe not everybody is aware, to our triumphs in the battlefield and also in the international campaign. We supported Israel's security for many, many years. It wasn't always that in every country. You came from your system and also in the general system and the court and never shunned away from addressing these issues, and I believe that it merely strengthened Israel's security and did not undermine it. Thank you very much.